Friends, this is a very short speech which I thought I will present in relation to section 12A, which is of the Commercial Courts Act 2015, the pre-mediation, pre-institution mediation. Commercial Courts Act, all of you is probably aware, one of the very interesting legislation, very efficient legislation aimed to providing resolution of commercial disputes and early disposal. And one of the very important provisions of this is 12A, which was introduced in 2018, saying that the institution of suit must be preceded by a mandatory mediation. Of course, the 12A has been thoughtfully worded that in relation to suits where there is an interim relief that is sought, then of course this 12A requirement will not arise. So which does not contemplate interim relief under this act is the language which is used in 12A. And we are going to discuss about two very different trademark matters. One is of course competitors in the marketplace, and in the other one is a family matter. Of course they are competitors between them. So I'm going to talk about this 12A and the impact of the 13(1)A appeal, and also the relevant matter facts in this case. You will find that the RKG GVJ suit is what I am thinking of talking about, and it is before the principal district commercial judge, district judge in commercial court in Tirupur in COS number 17 of 2021. 2021 the suit was filed. 29th April 2022, a relief interim injunction was granted against the defendants from using the mark, which means almost an year has gone by in the interim relief itself. However, the defendants were very quick to moving the High Court, and the interim stay was granted against the interim injunction granted against the defendants. So therefore, it was hardly for about 12 days. I think 12th May or 11th May 2022, the interim stay of the injunction was granted. Ultimately, the suit came to be disposed of by the Madras High Court in the appeal under 13(1)A by an order dated 20th June 2022. And this order is very simple. It is talking about directing the commercial court in Tirupur to dispose of this matter within 2 months. Now, generally looking at from the angle of commercial, trademark related, IPR related matter, 2021 to 2022, and within 2 months, let us say, even if it is taking to 2023 also. So quite very efficient. And the subject matter between RKG and GVG is, as you know, in all these trademark matters, the trade dress, the representation, the color scheme, the get-up. I mean, these are all the usual things that are going to be the subject matter of such suits. And even without this interim relief, mediation, as an outsider, when you look at the facts of the case, could have solved the problem. Because after all, in the marketplace, business owners must understand that they must not capitalize by in any form, maybe indicating directly or indirectly, because when you talk about a person with an imperfect recollection of memory, the moment he looks at the color scheme and representation, he is induced to believing it is that product which he wants to buy. And therefore, that is probably the subject matter in this suit also. And 2021 to 2022, the travel journey is very less, and probably it could have been resolved through mediation also. In contrast, I'm going to take you to the other case, which is also in the domain of trademarks, which is a trademark called Varalakshmi. There is a fight between the younger brother and the elder brother. And in this particular case, the original suit was filed before the Madras High Court, and the question which was very important was the territorial jurisdiction of the court. Because the plaintiff as well as the defendant, they are all people from the Namakkal, Salem districts. Originally it was all Salem districts only. And therefore a tough challenge was made whether the court has the jurisdiction to try this trademark suit and allegation of infringement, because probably you must be aware section 134 of the Trademarks Act confers a special jurisdiction on the place where the plaintiff, being the registered proprietor, carries on its business. Plaintiff. Normally it is the defendant's jurisdiction where you must go there and try this thing. But in trademarks, provided you are a registered proprietor as a plaintiff, you have the right to sue where the plaintiff's cause of action, where he carries on business, arises. So, in that case, though the suit was filed in Chennai, ultimately by a decision of the Madras High Court in this matter, I think it was a decision made by Dr. G. Jayachandran, Justice Jayachandran, on 27th April 2021. And that was directing the plaintiff to file the suit before the court, which has the proper territorial jurisdiction. The court said, okay, you can go to Namakkal or at the best Salem and try your this thing. So it is a returning of the plaint. Then the scene moves against this particular order, goes to again 13(1)(a), original side appeal. Now the matter comes up before Chief Justice then Sanjeev Banerjee, and a batch of matters of same nature. The main question that the court addresses in this decision is, the order was, I think the judgment and order was 23rd September 2021. And the main issue which was addressed in this particular batch of appeals by a common order is the extent to which appeals are permitted in respect of matters covered by the commercial courts. Very important. 13(1)(a), at the drop of the hat, you go because the order is appealable. That is the point, major question that was answered in the decision of the Madras High Court, Sanjeev Banerjee, on 23rd September 2021. Leaving that for the minute, slightly, let us deviate because our topic is on the mediation and the trademarks. Then, this court concurs with the finding that the cause of action has not arisen. I just wanted to, read one or two paragraphs which are very important, particularly para 111 of the, 111. This is something which, at the time when we frame the suit, file the suit, we need to define, we need to understand, because it's a commercial matter. What also appears to have countered with the trial court was some stray sales of the alleged infringing product was shown to have taken place within the jurisdiction of the court, that is in Chennai. And it is probably a stage-managed sale or a trap sale where a friendly shop owner is engaged to show as if a sale has taken place of the infringing product with the infringing mark. This was observation. And the court goes about observing again in another paragraph, on the basis of what is evident on a meaningful reading of the plaint, it will be very clear that the transactions relied upon for the purpose of demonstrating that a part cause of action is arisen within the jurisdiction of that court were all contrived and tailor-made only to invoke the territorial jurisdiction of this court, possibly to harass the defendants. The order impugned returning the plaint to the appropriate court before Salem or Namakkal does not call for any interference. Please see the language and the observations. Therefore, the court went about, referring to the decision of the Supreme Court. In the jurisdiction, whoever is practicing would have definitely read the decision of the Supreme Court in 2015 10 SEC 161 Indian Performing Rights Society, where 134 was clarified and said if the plaintiff is carrying on business at a particular jurisdiction where cause of action has also arisen, it is that court 134 ke liye you should file. That's an interesting decision which was referred by the Madras High Court in the 23rd September 2021. But the matter does not end there. It is, after all, going back to the trial court, and therefore it ended up in a commercial suit before the Salem court in district judge, before the district judge in Salem, suit number 22 of 2022. And after hearing the parties, the commercial court in the interim application orders a status quo to be maintained till the disposal of the suit. And the parties do not stop there. Again 13(1)(a). In the again 13(1)(a), ultimately it comes up before the acting principal Chief Justice by name the time Paresh Upadhyaya. Paresh Upadhyaya ji looks at the prayer before him as a very innovative prayer, and he says, okay, let us at this stage, 13(1)(a) stage, he orders a mediation before Justice Kalyan Sundaram in the mediation, Tamil Nadu Mediation and Conciliation Center, and directs the mediator to look at this matter. And innovative prayer that was talked about is the prayer to stay the proceedings before the commercial court in Salem during the mediation, and that stay was granted. So therefore, until 12(a) itself is not the one end of it, you can go beyond that also, is what I want to say. But I would like to wind up by quoting the latest decision of the Supreme Court. You would have read 17th August 2022 in Patil automation case. There are two paragraphs which you need to refer. One is, of course, the 84 para, the last penultimate para, I can say, in the decision. One second, I'll just read out the sentence which is important. We declare that 12(a) is mandatory. Hold that any suit instituted violating the provisions or mandate of 12(a) must be visited with rejection of plaint. That is the kind of language of 12(a) introduced in 2018. And the Supreme Court says in Patil automation, this power can be exercised even suo motu by the court as explained earlier in the judgment. Therefore, at any point of time, see what I am saying is 13(1)(a) also, or even in 12(a), if the interim relief is granted or interim application is disposed of otherwise or whatever manner, or if the court feels, okay, this interim relief cannot be granted now, we consider everything together also, court can always order mediation. It is not that it is pre-institution mediation alone. Therefore, Supreme Court in Patil automation, para number 74 is important, wherein as a matter of general proposition, the Supreme Court says that mediation can become a potent alternate dispute resolution device. There are, however, a few indispensable requirements. The first is the existence of the adequate infrastructural facilities. What is important is trained and skilled mediators. The role of mediators, as per Rule 5 of the rules, is to facilitate voluntary resolution of commercial dispute and assist the parties in how can a mediator who is not properly trained fulfill his responsibility? This is a question 74, para number 74, Supreme Court in Patil automations asked. Let us ask the same question, because litigation is something which can prolong for years. At the drop of a hat, an order can be passed, an application can be filed, fees can be collected, appeal can be paid, we can go from district court to high court and thereafter also. However, the idea of commercial court is efficiency in justice delivery system. And that efficiency is sought to be achieved in two ways. Number one, in the procedures, make the speedy disposal procedures have been cut down. The second is also the mediation, because if mediation results in resolution of the commercial dispute, you don't need to look out for the dispute resolution mechanism of the ordinary courts to come to the rescue. Therefore, Whether it is in this family matter, okay, at 13(1)(a) stage, the court has decided to direct the parties to go for mediation. In fact, the district court, the commercial court, District Judge Salem has observed that the subject mark is strewn between the parties such a way that both have been using it left, right, and center. So ultimately, as advisors, legal advisors, mediation could be tried. And the Supreme Court has cautiously said in this particular decision in Patil automation, there is a need to have a dedicated bar for mediation. Beautifully they have said. And the Supreme Court has also said the effective participation of the bar must be adequately remunerated for its services, because unless there is a remuneration which is generally available in litigation, you make an application, you file your written statement or counter and fight, there is a fees. In mediation, all these things will evaporate. Therefore, the Supreme Court has consciously and cautiously said that effective participation of the bar, which must be adequately remunerated for its service, will assist in mediation evolving. Thank you, friends. If you have some suggestions, thoughts, and comments, please feel free to pass it on to me. If you like this, you can like this video and also circulate it to amongst your friends, because ultimately we are talking about resolution of disputes. Thank you.